Good morning, Your Honour. I am Harrison McSweeney, counsel appearing on behalf of the applicant, Mr. Lewis Tucker. Your Honour, the defence is seeking a pre-trial ruling pursuant to Section 590AA2E of the Criminal Code to have certain Crown evidence excluded from the trial. Your Honour, I firstly submit that the DVD copies, posters, magazines and other train spotting memorabilia and the cardboard box obtained in the search of Unit B52 be ruled inadmissible on the basis that they are not sufficiently relevant. In applying the relevancy test from Goldsmith and Sandilands, the evidence is relevant if it could rationally affect, directly or indirectly, the assessment of the probability of the existence of Mr. Tucker carrying on the business of trafficking and or possessing dangerous drugs. I ask the question, Your Honour, does owning a DVD copy or other such memorabilia associated with a drug-related film automatically or make it more likely that the individual is a drug user or involved in drugs? To say yes, I would argue, is an extremely far-fetched assumption, and to be considered strong circumstantial evidence is completely irrational and inconceivable. It is not unusual for someone who enjoys a film to own a copy of it, thus why should Mr. Tucker be treated any differently to anyone else? In applying Shepherd and the Queen, the train spotting evidence has no rational connection to that of someone possessing or trafficking a dangerous drug. I further seek to exclude the cardboard box, Your Honour. A cardboard box exists in almost every household or premises. It provides no plausible support to the charges against Mr. Tucker. I secondly submit that it would be unfair to allow the train spotting evidence into trial and the court exercise its judicial discretion to exclude this evidence. In applying the test from Hasler, the train spotting evidence is of small probative value in relation to the charges of possessing and trafficking a dangerous drug. Your Honour, this is exactly the type of prejudicial evidence that can give rise to discreditable conduct, to which could easily influence a layperson's view without any rational connection or consideration as to whether the evidence is relevant at all. This could significantly damage Mr. Tucker's reputation and have a strong prejudicial effect against him in the trial. Your Honour, I further submit that all evidence be excluded due to the numerous breaches of the Police Powers Act, which will be referred to as the Act, making the warrant and search unlawful. Your Honour, the magistrate issued the search warrant. However, it is arguable that demolishing a supporting internal wall is more than merely, as Detective Anderson described to the magistrate, removing an internal wall to inspect insulation material. Removing an internal wall could simply require removing the panels to reach the insulation material, not demolishing the whole thing. Therefore, this has exceeded the power under Section 157(1)(k) of the Act, and structural damage of this nature required a Supreme Court judge to issue the warrant pursuant to Section 150 subsection 4 of the Act. Your Honour, Section 151 subsection B of the Act has been breached. Given that the warrant was issued on the 3rd of July and the police were of the belief that no drugs were on the premises till the 10th of July, there can be no reasonable grounds for believing that the prohibited items were at Unit B52 or would be at the premises within the next 72 hours after the warrant was issued. Further, Your Honour, Section 156 of the Act was breached. The search warrant was issued in relation to an offence in which specified that on the 4th of July, Mr. Tucker had possession and unlawfully supplied a dangerous drug. However, on this date, the police did not in fact find Mr. Tucker in possession or supplying a dangerous drug, thus no offence to which this warrant was issued had occurred. The warrant particularised the offences too generally, and in fact stated supply a dangerous drug rather than trafficking, and failed to outline the termination date and time. Further, as per Section 150A of the Act, a copy of the search warrant is to be given to the occupier. Here, Detective Anderson failed to leave a copy of the search warrant at Unit B52, knowing Mr. Tucker was not present. It is noted that Section 158 subsection 2 cannot apply as the police officers departed the premises and none remained to observe the premises. Finally, Your Honour, I submit that all evidence be excluded as a matter of public policy whereby it has been improperly and unlawfully obtained. Your Honour, in the case of Bunning and Cross, which considered this very issue, the court set out 5 factors to determine whether to exercise their discretion to exclude admissible evidence on public policy grounds. In applying the 5 factors. Number 1, Your Honour, society has a right to insist that those who enforce the law themselves respect it. The conduct of the police officer demonstrated a deliberate breach of law in exceeding and blatantly ignoring the powers and duties outlined in the statute. We must remember that Mr. Tucker was leasing this unit. He didn't even own it. And the police came and conducted an unlawful search for what? 110 grams of heroin. Hence, the problem here is the complete disregard for civil rights, promoting improper police procedures, more so than the potential for 110 grams of heroin to be harmful to the community. Number 2. As indicative of the police's conduct, the heroin was well placed into the wall and would not have been lost permanently if the police hadn't obtained the evidence in the way that they did. Number 3. The conduct was not a genuine response to pressing circumstances, as the items would have remained in the unit the next day based off the police's suspicions. The police cut corners as a matter of complete convenience. Your Honour, was it really appropriate and proportional to the police's suspicions for them to come onto Mr. Tucker's premises and smash down a supporting wall? This would only be so if they had actually gone through the proper procedures. 4. The gravity of the charges are not minor. However, the evidence was obtained in an unlawful manner, which is crucial to public confidence in the judicial system and would lead to an improper trial. 5. Your Honour, the conduct breached numerous sections of the Act, in which one has its sole purpose in Section 5E to ensure fairness and protect the rights of the persons to whom these powers and responsibilities are exercised. Your Honour, how can this be upheld when condoning conduct such as this blatantly fractures the public's immunity from arbitrary and unlawful intrusion? Your Honour, in applying these factors, the balance of considerations must weigh in favour of excluding all evidence. Otherwise, the potential conviction obtained by the aid of unlawful evidence will be obtained at too high of a price. Those are all the submissions. Thank you, Your Honour.